Good afternoon. My name is Kim Stanger, and on behalf of Holland & Hart, we'd like to welcome you to today's webinar dealing with telemedicine issues. A few preliminaries. This is another one of our webinar series that we do a monthly webinar dealing with different health law issues. Today's focus is going to be on telemedicine. It's kind of an overview that I'll talk about in just a minute. But when we're talking about telemedicine, it's probably a good idea to get some of the syntax out first. I think a lot of people will, a lot of the wonks out there will identify different types of telemedicine or telehealth or difference between the types of telemedicine or telehealth. But for purposes of today, I'm going to be fairly generic. Telemedicine is the provision of clinical services to patients by physicians and practitioners from a distance via electronic communications. Now, telemedicine may be either simultaneous or real-time, like tele-ICU, telecardiology, or something like that, where they're looking at the patient real-time, communicating with the patient real-time, or it can be non-simultaneous, store and forward. For example, teleradiology, where the teleradiologist may look at it, they send off the slides or the images, and sometime down the road, the local radiologist or the local physician will take a look at it. When we're talking about telemedicine, we always have two different sites. You've got the originating site, that's where the patient is located, and then you've got the distant site, that's where the remote practitioner is located. The issues that we're going to cover today are kind of broad and varied. We're going to talk a little bit about licensure issues, limits on remote prescribing, the corporate practice of medicine, credentialing issues, some liability issues that arise in the telemedicine context, privacy and security concerns, and some reimbursement issues. Now, we're going to be providing kind of a general overview of these issues. We're not going to go into any of them in any real depth. We don't have the time to do that today in our hour-long program, but we wanted to give you kind of an overview so that you could spot the red flags when it comes to dealing with telemedicine issues. When we're talking about this telemedicine stuff, just remember this, that the law really has not caught up with technology and telemedicine. A lot of the laws that we deal with were written years and years ago before there was anything called telemedicine. So some statutes and regulations simply may not address telemedicine, whether it's in licensing, whether it's in credentialing, or the like. In addition, even where the statutes and the regulations may address it, there's relatively few cases out there defining what those cases might need. But the law is changing on that, especially over the last couple of years. There have been quite a few states that have adopted telemedicine rules. Now, so you need to make sure that you're up on those rules that may apply in your particular state. We have very few, if any, national telemedicine rules. Most of these rules are determined based on state law, and those state laws may differ. I'm going to focus today primarily on the federal laws or those common laws that apply in most states. But when it comes time to apply, it's important that you check the laws that are applicable in your particular state. Also, when you're dealing with telemedicine issues, you've got to be concerned about not only the laws in your particular state, but if you're a distant site provider, you're reaching out to provide telemedicine in another state, you've got to be concerned about the laws in that other state, because there's a good chance that those laws in that other state are going to apply to you even though you never set foot in that other state. As far as written materials, we've provided a whole bunch of stuff for you, including some documents prepared by the Federation of State Medical Boards, an overview of telemedicine laws that provides a pretty good 50-state survey. That was prepared just this past year. In addition, I provided another publication that's a 50-state survey from the FSMB concerning state internet prescribing language, internet prescribing statutes. In that situation, that particular summary is a couple of years old, but nevertheless it's helpful. I've given you some guidance from CMS concerning the current Medicare payments for telemedicine issues. I've even given you some additional documents from the State Operations Manual dealing with credentialing by proxy for those of you who are working with hospitals. I've provided you with a sample agreement for credentialing by proxy. We'll talk a little bit more about that later, and some sample medical staff bylaws for credentialing if you're a hospital. I've given you an article talking about HIPAA emails and text to patients or others that's relevant to the telemedicine issues. And for those of you guys who are in Idaho and have an interest, I've given you a copy of Idaho's new Idaho Telehealth Access Act. Finally, this program, like our other webinars, will be recorded and available for download in case you don't have anything better to do this weekend and want to listen to it again. Or you can, as we go along, if you have questions, you can send those questions to me either via the chat line that's through the WebEx program, or if you want to talk to me offline, go ahead and email me at my website. All right. With those preliminaries out of the way, let's talk about telemedicine issues. The first issue that comes up is licensure. Licensure, who cares? After all, you're a telemedicine provider. What do you care? If you're going to provide telemedicine over into another state, you never go into that state. Why in the world do you care about licensure in that other state? Well, you ought to care because you may be subject to criminal, civil, or administrative sanctions if you're not properly licensed in the state where you are providing the telemedicine services in the originating site. In addition, you may lose liability insurance if you're not properly licensed. There may be no reimbursement for the services that you provide. If you're the originating site, you have to be concerned about your own liability insurance, that whether or not it may cover that remote practitioner. You may not get paid for the reimbursements for the services if that other practitioner is not licensed. You could have your own facility licensing problems if you haven't complied with the conditions of participation or other documents or other requirements that may apply. And if nothing else, you may be subject to negligent credentialing if there's a bad outcome and the plaintiff's lawyer finds out that you didn't do the proper credentialing and this other physician who is providing services via telemedicine was not licensed in your particular state. State licensure, well, your states generally regulate the practice of medicine, which is defined as something like the following. Most states have this same type of definition of the practice of medicine. It includes to investigate, diagnose, treat, or prescribe for any human disease, ailment, injury, or other condition by any means or instrumentality, or to apply principles or techniques of medical science in the prevention of such conditions, or to offer, undertake, attempt, or hold oneself out as able to do any of the foregoing. Hey, guys, that's telemedicine stuff. When you're engaging in telemedicine, you are probably investigating, diagnosing, treating, or prescribing for a human disease. That means that you're practicing medicine. And if you're doing that without a license, you can be subject to all sorts of bad stuff, including most states will make that a felony. You could go to jail for practicing without a license. You could be subject to criminal fines, prison, or, if nothing else, adverse action against your licensure. At least in Idaho, that's the way that it would shake out. Now, the practice of medicine is usually interpreted as occurring not only where the distant site physician is located, but also where the patient's located. If you're a regulator in the state where the patient's located, you have an interest in making sure your citizens are protected, and therefore they're generally going to interpret their statutes to apply to those physicians, those telemedicine providers who are providing services to patients in their particular state. The state in which the patient is located will usually apply its own medical malpractice laws or medical practices law. That means they're not going to look at the law that may govern you at the originating site or at the remote site. They'll look at the laws at the originating site and hold you to those standards. The net effect of that is the telemedicine provider must generally be authorized to practice in the state where the patient is located. Now, either they could do that by having an express license to provide medicine in that particular state, or maybe they fit within an exception to the licensing rules. States vary concerning their telemedicine licensing rules. Most states still require that providers engaging in telemedicine must have a full medical license to provide telemedicine services in that particular state, that there are no special exceptions for telemedicine providers. Some more progressive states do allow a special purpose or a limited license for telemedicine providers, but that's a relatively new development, and those states are relatively few in number. Most states, even if they require licensure, they will have some type of exception that may or may not apply to telemedicine situations. For example, they may have an exception for licensure requirements for providing education, or if they're providing services, the physician's providing services in an emergency or as a good Samaritan, or if they're just providing services as a consulting physician, so long as they have a local physician involved in the originating state and the remote practitioner does not have an office in the state. So the remote practitioner is really a situation where they're just responding to an isolated situation where they're providing a consultation to a physician who otherwise has the direct patient relationship in the originating state, and that telemedicine provider is not reaching out to provide services in that particular state on a regular basis. On the other hand, if you're a telemedicine provider and you have a contract with a hospital or other health system to provide telemedicine services in another state, then you probably are not going to fit within that consultation exception. You better darn well make sure that you've got the appropriate licensures. Now, there are some exceptions. For example, practitioners in the military, the VA system or the public health services, they don't have to be licensed in any particular state. As long as they're credentialed by the VA, PA, public health service, or the military, then they can practice within their organization. So they can provide services at, for example, the VA hospital. On the other hand, they can't go outside and provide services outside their organization without having to be licensed in that particular state. There's also the Nurse Compact Act that allows for those states that participate in the Nurse Compact that it gives reciprocity. So the nurse practicing in, that's licensed in one state, if they're a member of that compact, they can practice in other states that are members of the compact. Now, interestingly enough, new development hot off the press. This past year, the Federation of State Medical Boards has developed a model interstate medical licensure compact that kind of works for physicians like it would for nurse practitioners. Under this interstate medical licensure compact, if you are licensed in a particular state, and if that state is a member of the compact and you want to go into another state that's a member of the compact, then you can get this expedited licensure process. You still have to go through the licensure process. You still have to be licensed in that state in which you want to provide telemedicine services. But if they are a member of this compact, there's an expedited process that allows you to get that licensure more easily. When this was promulgated, it required a certain number of states to come on board, kind of a critical mass. As I recall, it was 7 states. Well, we now have at least 10 states that have adopted this participation in the medical licensure compact, including Idaho, Montana, Nevada, Utah, Wyoming, South Dakota, and several others. So if you are in those states, then guess what? Good news. You've got an easier process in order to get licensed so that you can provide telemedicine services so long as both the originating site and the distant site are members of this compact. Now, it'll take a little while to get this compact up and running. They've got to establish the organization. Now that they do have the requisite number of states involved, I suspect that it'll probably be a year or two before this is actually up and running, but there is relief on the way. If you are practicing at a hospital, then you also have to be concerned about the hospital conditions of participation, or if you are a hospital who engages in telemedicine. Under the hospital conditions of participation, healthcare professionals must be legally authorized to practice in the state where the hospital is located. When it comes to telemedicine services, it's even more specific. The interpretive guidelines for the regulations state that when telemedicine is used and the practitioner and patient are located in different states, the practitioner providing the patient care service must be licensed and or meet the other applicable standards that are required by the state or local laws in both the state where the practitioner is located and the state where the patient is located. So you got to be licensed in both states to satisfy the Medicare conditions of participation. If you don't satisfy the Medicare conditions of participation, then that can create issues for the hospital. Medicaid laws are similar. Most state Medicaid laws require that the practitioner is licensed within the state as a condition for reimbursement. So if you want to get paid for your telemedicine services by Medicaid, you generally have to be licensed in the state of the Medicaid program. Specifically, the government publication states that Medicaid guidelines require all providers to practice within the scope of their State Practice Act. Some states have enacted legislation that requires providers using telemedicine technology across state lines to have a valid state license in the state where the patient is located. Any such requirements or restrictions placed by the state are binding under current Medicaid rules. So you have to look at the particular state in which you want to practice. When it comes to licensure, the rule is that the remote practitioner in the originating site should ensure that the remote practitioner is licensed in or otherwise authorized to provide the telemedicine services in the originating site state. So you need to make sure that you satisfy the licensure issues. Next issue. A lot of states have restrictions on remote prescribing or treatment. These primarily arose out of the online pharmacy cases. When, the internet came into vogue, you started having all these online pharmacies, and these online pharmacies had a process whereby, patients could log on there, they could answer a questionnaire online, and the online pharmacy would have a physician who would issue these prescriptions. Now, that physician never had a face-to-face encounter with the patient. They were just issuing the prescriptions based on these online questionnaires. Well, a lot of states and or the state medical boards didn't like those situations. They were concerned, maybe because of the competition issue, more likely because of the quality of care issues that raised. And in response, many states or medical boards issued rules or promulgated statutes that require an in-person physical exam before allowing the practitioner to prescribe or render treatment. That's either done under the Medical Practices Act expressly or maybe by some interpretation or policy or rule that's issued by the state medical boards. In the documents I provided to you, I have given you a summary of those state laws that was issued by the FSNB. So you may want to look at that and see what your particular laws are when it comes to allowing these types of telemedicine services without first having some kind of direct patient encounter. There's an interesting case that's currently brewing in Texas dealing with this particular issue. Back at the end of last year, the Texas Board of Medicine issued an emergency rule that essentially required all providers to have an in-person, face-to-face encounter with the patient before they could go ahead and prescribe treatment. Well, Teladoc, which is one of the nation's largest telemedicine providers, they didn't like that, and they ended up suing the Texas State Medical Board for antitrust violations, stating that by engaging in this conduct, you're engaging in anti-competitive conduct in violation of the federal antitrust laws. They kind of piggybacked on the Supreme Court's decision from last year against one of the dental boards. Well, they sought as part of that a preliminary injunction, and last month the Texas federal judge ruled in Teladoc's favor. Now, in the process of that, he granted a temporary or a preliminary injunction that limited the state medical board from enforcing that rule. As part of that ruling, the judge essentially concluded that based on the evidence that was presented to him at that particular point in time, it did not look like that rule issued by the medical board was justified. Now, this was the state of this. It was a request for a preliminary injunction. So all of this is preliminary. The lawsuit will still continue. It's just that this preliminary injunction has now issued so that it limits the Texas board from enforcing that rule until final resolution of the lawsuit. So it's all preliminary. The lawsuit's still going forward. I believe that the Texas board recently filed a defense claiming that the antitrust acts don't apply to it because of state action immunity. So we'll have to play out. But the bottom line is this. You may now see other situations where telemedicine providers may go after medical boards who are imposing these in-person requirements and arguing that those in-person requirements may violate antitrust laws. So we'll have to watch and see what happens in Texas, see how that shakes out. Here in Idaho, we had a similar case that got national attention. There was a situation where a physician up north who actually had an Idaho license, but she prescribed some antibiotics for a patient over the phone without having had an inpatient person-to-person encounter with that particular patient. The Board of Medicine decided to go after her. Interestingly enough, it wasn't based on any kind of licensure action. It was a standard of care issue, arguing that the physician failed to comply with the appropriate standard of care by issuing that prescription without an appropriate examination. Well, that created kind of a flurry around here, which ultimately resulted in new legislation here in Idaho, which is similar to legislation that's been passed in other states. The Idaho Telehealth Access Act now states that providers can establish a patient-provider relationship via a two-way audio and visual interaction. So the physician doesn't necessarily have to establish that relationship in person in order to be able to prescribe under the Idaho statutes. But even though you can establish that patient-provider relationship via a two-way audio or visual interaction, that physician who's providing the telemedicine services still must be licensed to or authorized to provide the services in Idaho, so it doesn't change that. In addition, that physician still must comply with the community standard of care. So even though they are providing the services via telemedicine, they're still going to have to comply with this community standard of care. Presumably that means if the community standard of care would require some type of in-person evaluation, then simply provided the treatment via telemedicine may not satisfy the statute, and the Board of Medicine may go after you. There's some other requirements that that provider providing the telemedicine must obtain and document the patient's history and symptoms. They've got to maintain documents and have them available for others to review. The treatment has to be based solely on, the treatment that is based solely on an online questionnaire will not satisfy the applicable standard of care, so you can't just rely on that. You've got to obtain informed consent. You've got to provide, be available for follow-up care or provide information to patients as requested. It's not kind of a one-and-done type telemedicine services. And you cannot prescribe a drug for abortion through the telehealth services. Footnote on that one. The Iowa Supreme Court, the Iowa, not Idaho, the Iowa Supreme Court recently ruled that a similar telemedicine limitation that prohibited prescribing drugs for abortions, the Iowa Supreme Court held that that violated the Iowa Constitution, so we'll have to see how that plays out. Now, with regard to the Idaho Telehealth Access Act, the Board of Medicine has issued proposed rules, or is in the process of coming up with the proposed rules to implement all of this, so if you're in Idaho, stay tuned. The Idaho statute actually follows fairly closely with recent guidelines that are issued by the AMA for telemedicine. The AMA developed recommended ethical guidelines for telemedicine services, which suggested that the patient-physician relationship, you still have to have that, but it could be established through either a face-to-face, well, it has to be established by a face-to-face examination, but that could be established either by in-person contact or real-time audio and video technology. There's certain exceptions for consultations, radiology, and pathology. So the appropriate AMA organization, they developed these guidelines, but those have kind of stalled now. The House of Delegates has currently tabled it, so we'll have to watch that. The bottom line is, when it comes to prescribing or providing treatment without a prior established relationship with your patients, you better check your individual states' laws and regulations and board interpretations to determine whether or not you can do that without violating those rules. All right, next issue you've got to be concerned with is the corporate practice of medicine. The corporate practice of medicine states that in some states, physicians cannot be employed by corporations or non-physicians. The theory here is that, hey, Medical Practices Acts, they only allow physicians to practice medicine. They don't allow other non-physicians to practice medicine. And if you are a non-physician or a corporation who is employing a physician, that means by definition you have a right to control the physician, and we don't like that. We think that that interferes with the physician's judgment. So in these states that follow the corporate practice of medicine doctrine, those physicians cannot be employed by a corporation, or they can't be employed by a non-physician. And that result of that is, if you want to go ahead and provide services in another state that apply this corporate practice of medicine, that means you're going to have to comply with any rules that apply in that particular state. You may not be able to function as a teledoc or another entity that is a corporation that it just simply employs physicians to go ahead and provide those services across the state lines. Now, What happens if you violate that? Well, there could be penalties that include fines, adverse licensure actions, or more frequently, simply an injunction that tells you, hey, quit it, you can't do that type of stuff. Now, even in those states where the corporate practice of medicine is recognized by statute or by case law, it's usually subject to certain types of exceptions. For example, the statutes will usually expressly allow or contemplate that certain types of entities may employ physicians directly, such as hospitals, managed care organizations, or other licensed entities in the state. In addition, they will allow professional corporations or professional limited liability companies to employ physicians. Professional corporations or professional limited liability companies are those companies where all of the stockholders or all of the members are physicians, and therefore the theory is, hey, the statutes were created to specifically allow these physicians to function as corporations because physicians control it, physicians own it, therefore it doesn't violate the corporate practice of medicine rule. In addition, in most states, the corporate practice of medicine rule only applies to employing physicians. To the extent you want to independently contract with physicians to provide these services, such as telemedicine services, in most states, the corporate practice of medicine would not prohibit that. That's why when you go into other states where they have the corporate practice of medicine, quite often you structure your deal as an independent contractor arrangement with those physicians rather than employing them directly. The corporate practice of medicine doctrine generally applies to physicians. It usually doesn't apply to mid-levels. All right, that's the corporate practice of medicine. Let's talk briefly about credentialing and privileging. No surprise, states usually require healthcare facilities to credential practitioners if they're going to provide services at that hospital or other facilities. That could either be required by state statutes or licensing regulations or payer requirements. It could also be imposed by a common law tort duty, that if you fail to properly credential these practitioners, then you may be liable for negligently credentialing or failing to credential those practitioners. Most medical staff organizations will require that you conduct credentialing. Now, some of those statutes, regulations, or bylaws, it's not only that they require the credentialing, but they require individual credentialing. That means that you have to credential each one of those practitioners yourself. You can't rely on credentialing done by others. That's called credentialing by proxy. As I mentioned, a lot of the state statutes, the regulations, a lot of your bylaws have been around for years and years and years, and it's never been updated to take into consideration telemedicine issues. Individual credentialing is problematic when it comes to telemedicine providers. For example, the facility may have many providers rendering telemedicine services, such as teleradiology. A lot of your entities may contract with an entity like used to be Nighthawk, where you would contract with them to provide teleradiology services, and you never know who's going to be providing those services on the other end. It could be somebody in Australia or India. How in the world are you going to individually credential all of those people? In addition, a facility may not be qualified to assess the competence of those telemedicine providers. Chances are you are getting telemedicine services specifically because you don't have those services available by a live person on staff at the facility. That's why you need the telemedicine services. So you may not have the ability to do effective internal credentialing. Well, for a long time, the government said, we don't care, you're still required to do individual credentialing when it comes to compliance with the hospital conditions of participation. However, a few years ago, the government changed on that. Now, the hospital conditions of participation do allow credentialing by proxy for telemedicine providers. That means that the originating site hospital can accept and rely on the credentialing that's done by the distant site. Instead of having to credential each of these people themselves, the originating site hospital can rely on the credentialing that was done for those providers at the distant site, so long as certain standards are satisfied. In particular, you can only rely on that credentialing by proxy if the originating site hospital or critical access hospital satisfies certain criteria, including that they have an agreement between them that includes certain requirements set forth in the regulations. Now, those conditions of participation only allow credentialing by proxy for telemedicine privileges. They do not allow credentialing by proxy for other types of services that are not telemedicine, so don't try to expand this into other areas. In addition, if that practitioner is going to provide both telemedicine and non-telemedicine services and you want to participate in Medicare, then you are still going to have to do individualized credentialing for the non-telemedicine services. Just because they provide some telemedicine services, it doesn't extend credentialing by proxy to the non-telemedicine stuff. Now, so for telemedicine services, a hospital or a critical access hospital or a CAH, their governing board has the option. They can decide whether or not they want to allow the medical staff to rely on credentialing by proxy, to rely on the credentialing that's done by the distant site entity, or the board could say, no, we don't want to rely on that, we're going to do the credentialing ourselves, and we're going to handle that credentialing internally and not rely on credentialing by proxy. When the surveyors show up to survey you for compliance with the conditions of participation, they will check to see whether or not you're complying with the telemedicine or the credentialing by proxy rules. Specifically, the guidelines for those surveys process, the surveyor is supposed to ask the hospital if it uses telemedicine services, and if yes, the surveyor will ask to see a copy of the written agreement with the distant site hospital entity. Remember, you've got to have that agreement in place if you're going to credential by proxy. Then they'll ask, does the hospital have documentation that it granted privileges to each telemedicine provider? Even though you're credentialing by proxy, you still have to grant privileges to the individual providers. It's just you're going to rely on the credentialing that was done by that remote site entity. And then the surveyor is going to ask, does the documentation indicate that for each telemedicine provider there's a medical staff recommendation, including whether the medical staff relied on the distant site to do the credentialing for the written agreement or conducted its own review? You still have to credential telemedicine providers. The only question is whether or not you're going to credential them by proxy or whether you're going to credential them yourself. Under the conditions of participation, if you're going to do the credentialing by proxy, you've got to have this written agreement. That written agreement has to contain certain requirements. In addition, the board has to agree to comply with certain types of requirements. In the interest of time, I'm not going to go through those. Just remember this, that if at your facility you want to credential by proxy, you need to pull out the regulations and make sure that you've got the written agreement in place that satisfies the conditions of participation. That agreement is going to vary depending on whether you are a hospital or whether you're a critical access hospital. The rules are slightly different for each. In addition, the rules are going to differ slightly depending on whether or not that distant site entity, whether it is a Medicare participating hospital or whether it is some other entity that has not participated in Medicare, for example, a teleradiology group. In those situations, your obligations are going to vary a little bit differently. You need to make sure the contract is addressed properly to take into consideration those issues. Among the other information that I provided to you today, I gave you a sample contract. The sample contract that I gave to you is drafted for a critical access hospital doing contracting with a distant site entity to provide those services. If you're not a critical access hospital or you're not contracting with a distant site entity to provide those services, you would need to modify that contract accordingly. I've also given you a copy of the State Operations Manual Interpretive Guidelines telling you how you need to implement these issues. Again, those rules apply if you are a hospital or you're going to contract with a hospital to provide telemedicine services at the hospital. Now, the conditions of participation, the Joint Commission requirements do allow hospitals to grant emergency privileges in limited circumstances. Usually while the normal credentialing process occurs or if there's a unique patient care need. But those emergency services, that's normally limited for a relatively short period of time, usually no more than 60 days. It has to be subject to a limited preliminary review. It's not quite clear how that applies to telemedicine providers. Presumably you could grant a telemedicine provider those emergency privileges as long as you otherwise satisfy this. Not clear how that really works with telemedicine if you're going to credential by proxy. So I throw that out there, but that may be another option for you to look at in credentialing telemedicine providers. If you are a hospital, you're probably going to want to go back and look at your medical staff bylaws to ensure that you've got the telemedicine that your bylaws adequately allow for credentialing for telemedicine providers. That means that you may need to update your bylaws to address things like the qualifications of the medical staff members. Do the qualifications apply, or do telemedicine providers satisfy the qualifications in your bylaws? For example, your bylaws may say that only to get medical staff membership, you have to reside within a certain geographic proximity, or you have to have a certain number of physicians. You may need to modify that if you're going to grant active medical staff membership or other membership categories to telemedicine providers. You ought to consider the categories of medical staff members. I would recommend that you add a special category for telemedicine staff, that so certain qualifications have to be satisfied with those telemedicine staff members. Among the other documents that I gave to you, I think that I gave to you some sample bylaws provisions that you could incorporate into your medical staff bylaws that would address telemedicine issues. When it comes to privileges, you need to make sure that your bylaws would allow for the granting of telemedicine privileges. The credentialing process has to allow for credentialing by proxy. If your medical staff bylaws don't allow for credentialing by proxy, if they require credentialing individually, then you could get cited for a violation of the conditions of participation when the surveyors come along, because the survey process requires a review of medical staff bylaws to verify that your credentialing process satisfies those medical staff requirements. All right, that is the credentialing issues. Let's talk next about some of the liability issues that arise in telemedicine situations. The first is negligent credentialing. I already mentioned this briefly. In some states, hospitals or other providers may be liable in negligence, the tort of negligence, if they fail to properly credential those granted privileges. The theory here is that, hey, we came to you, hospital or other facility, to receive this care. We relied on you. You had an affirmative obligation by statute or by common law to ensure that you're only giving privileges to those people who are really qualified to provide services at your facility. If you fail to properly credential those people and the patient suffered harm as a result of that, you could be liable for negligent credentialing. Now, it's not clear whether the conditions of participation standards for credentialing by proxy would satisfy the tort standards for proper credentialing. It may be that, yeah, the government, the federal government, for purposes of Medicare, they will allow you to credential by proxy, but it may be that your particular state would impose a higher standard. Remember, negligence is normally determined by the local standard of care, and if your local standard of care is not credentialing by proxy, but it is individual credentialing, then the argument might be that, hey, credentialing by proxy doesn't work. It may satisfy the conditions of participation, but it doesn't satisfy your duty of care in this particular state, or may not satisfy your state statutes, because your state statutes or regulations still may require individual credentialing. Bottom line there is you may want to look and make sure that if you are going to engage in credentialing by proxy, that you satisfy the local standard of care as well as your state statutes. If you're going to be engaging in telemedicine, remember that you're going to be crossing state boundaries. That means you're going to be subject to the laws of that other state. Things like licensure requirements, professional standards, or the standard of care. You may be used to the standard of care in your individual community, but suddenly when you're engaging in telemedicine, you're going out into this other location. You may now be subject to the standards that apply in that other location. Informed consent rules may apply. In that different informed consent rules may apply in that other state than you're used to. Statute of limitations may differ. There may be caps on damages that differ. You may, for example, if you were in Idaho, you may be used to the cap on damages here, but if you're going to practice in another state, that other state may not recognize those caps on damages, so suddenly you may be subject to greater damages than you otherwise envisioned and may need to get additional insurance coverage. Some states have like a pre-litigation screening process like we do in Idaho, but if you're going to go to another state, maybe you don't get the benefit of that. The reimbursement rules may differ in Medicaid payment in another state or with other payers. Confidentiality requirements may differ. Just remember this. that if you're going to engage in telemedicine, you got to not only worry about the laws in the state where you reside, but also you've got to be aware of and realize you may be subject to completely different laws that apply in that state where you're going to be providing the services. Not only may the substantive laws differ, but if you're going to cross those state boundaries, the other state may have different procedural rules that apply. Things like the pre-litigation screening panel, notice of tort claims, pleading punitive damages, the physician-patient privilege, peer review privilege, evidentiary rules, all of those other procedural things may change once you go out of your state to provide telemedicine services elsewhere. Sometimes telemedicine providers don't really think about the practitioner-patient relationship because, after all, that patient is way over there. Maybe you feel like you're just consulting and you're really not providing telemedicine services. But anytime you're going to engage in telemedicine, you need to be concerned about whether or not you have, either intentionally or unintentionally, created a practitioner-patient relationship. Because once you create that practitioner-patient relationship, it creates all the associated duties. That if you breach those duties, you can be liable for malpractice. To determine whether or not that practitioner-patient relationship exists, you generally have to ask yourself this: would a reasonable patient believe that, hey, I'm their doctor, that we have a practitioner-patient relationship? You as the doctor may not believe that, but ultimately the test is probably going to be, would a reasonable person, would that reasonable juror think, what do you mean you weren't the doctor? Of course you were the doctor. You were answering those questions, you were providing these services, and therefore you have relationships. That means that you're going to have to assume the responsibilities of providing effective care with that patient. Some of the factors that may go into establishing whether or not that practitioner-patient relationship exists are things like, did you have direct communication with the patient, direct contact with the patient, or were you simply consulting with the treating physician? Did you have a contract or agreement to provide care to that patient, either directly with the patient or with the hospital or with maybe a managed care organization? And of course, if you billed for the services, did you bill a patient for the services? If you are, then chances are you're going to be deemed to be their physician. Now, some states may, as I mentioned earlier, have an exception for consultations where you really don't, if you're just simply a consulting physician, a curbside consult, that you don't become a treating physician. There is no patient-physician relationship established, but you'd have to look at your particular state to see whether that applies. Assuming that a physician or practitioner-patient relationship applies, then malpractice liability is going to be triggered. You're going to be subject to the applicable standard of care. Now, that standard of care may differ in the community where you are providing those services remotely than the community that you are used to. In addition, you have to be consider the difference in the standard of care that may apply to telemedicine services. Now, most states, this may change, but most states currently would hold you to the same standard if you're providing telemedicine services as if you were providing those services in a face-to-face encounter with the particular patient. Under the new Idaho statute, they specifically state that, hey, you as a telemedicine provider, you're going to be held to the same standard of care as if you were there in person. So you need to be aware to make sure that you're still complying with the standard of care even though you're providing the services by telemedicine. You may not get the benefit of a lower standard of care just because you decide to provide the standards via telemedicine. So you ought to ask yourself, is the use of telemedicine appropriate for this particular patient's care? Or should it be handled in a face-to-face, real-time, live encounter? You got to consider the sufficiency of the telemedicine equipment or technology. Is it going to impose limitations on your ability to effectively provide care? The training, consider the training and qualifications of the users. Are they able to effectively use the equipment to satisfy the standard of care? What are the effect of other laws? Or are you going to have vicarious liability for others, including the remote practitioner and originating site personnel, even though you're not right there, but you're still issuing the orders? You may have vicarious liability for what those other people do. Informed consent still applies to telemedicine providers. It's especially important in the telemedicine case because you need to make sure that if you're providing that telemedicine that you inform the patient of the risks and benefits not only of their care but their care by telemedicine. So you should know the relevant laws for effective informed consent, not only in your state, but in the state where the patient's located. That informed consent should generally include a discussion of the risks, benefits, and limitations of telemedicine services, including the availability of the services and the provider. If you're not going to be available 24/7, you ought to explain that. Any technical limitations that may apply. You should identify the persons who are involved in providing the care, whether you're going to record the telemedicine sessions, and for purposes of privacy and security, you ought to advise them of the limitations or the risks, especially if you're going to use an open network. I'll talk about that in just a minute. To the extent that there are going to be non-employees, non-agents involved in the care, you'd ought to disclaim responsibility for those entities that you're not your agents. For example, your consent form with your telemedicine patient should identify that, hey, the agents at the remote site or at the originating site, those persons providing services there, they're not my agent, I'm not responsible for them. Telemedicine providers have to be concerned about patient abandonment. Once you establish that patient relationship, you generally are obligated to continue to provide services until you properly terminate the relationship. If you fail to do so, you could be liable for patient abandonment. Patient abandonment normally occurs if you discontinue treatment or terminate treatment and fail to give the patient sufficient time to transfer their care someplace else. If you do that, you could be subject to tort liability, the damages that the patient might suffer. Even if the patient doesn't suffer any damages, your State Medical Practices Act probably allows the Board of Medicine to go after you for an ethical violation for patient abandonment. To avoid patient abandonment claims, you generally have to do the following. You need to ensure the patient understands the scope and limits of the practitioner's involvement in the care. If you're not going to be providing ongoing care, you ought to make sure that the patient understands that, and that's just part of the deal. You can do that through the informed consent or a written agreement or notice with a particular patient. If you're going to terminate the relationship, you should give the patient adequate notice and the time to transfer their care before actually stopping to provide the care. If you're in the middle of, for example, you're providing oncology services or cardiology services or some other type of service, you're in the middle of a treatment regimen, you may not be able to terminate that relationship until you complete that regimen. Ultimately, it would come down to a question of what is reasonable under the circumstances and whether your actions harm the patient. You need to be concerned about liability insurance coverage. Just because you have liability insurance coverage does not necessarily mean that that liability insurance would extend to services you provide in telemedicine or services you provide in another state. It may be that your coverage is only for services you provide in the state in which you are licensed. And if you're not licensed and provide services in that other state, but you're providing telemedicine services over there, you may lose insurance coverage. Your coverage may not apply to the unauthorized practice of medicine. So if you're providing services in a state where you're not authorized to practice that medicine, you're not licensed in that state, you may lose coverage for that. You may not, your insurance coverage may not apply to certain types of actions that are taken against you. Maybe not malpractice, but maybe administrative or licensure actions or criminal actions. Maybe the other state decides to go after you for the unauthorized practice of medicine. They sue you for criminal actions or take criminal actions against you or bring administrative actions against you. Your insurance coverage may not apply to those types of actions. The bottom line is you ought to check your insurance coverage to ensure you've got coverage for any telemedicine services in which you want to engage. If you are the originating site hospital, you may want to make sure that any telemedicine providers with whom you are contracting to provide services ensure that they have appropriate telemedicine coverage is going to make sure they've got coverage. So if you're sued, you can turn and point the finger at that other entity, and there's a deep pocket that can also join in any settlement. Let's talk briefly about privacy and security issues. Well, privacy, that's pretty easy. Privacy applies to telemedicine just like other types of services. Just be careful there. You generally have to implement appropriate safeguards. The real concern when it comes to telemedicine are the security rules. Under the HIPAA security rules, you've got to implement specific administrative, technical, and physical safeguards to protect electronic protected health information. So any of that protected health information that is flowing back and forth, via telemedicine, that's got to satisfy the HIPAA security rule if you are a covered entity and engaged in electronic transactions. That security rules, these security rules aren't only designed to protect the confidentiality of that information, but also to preserve the integrity and availability, to make sure that the data is appropriate when you receive it, that it hasn't been modified or corrupted, that you can rely on it. You've got to make sure that the data is available so that if, for example, your computer crashes or you have a fire in your facility, that you still have that data available to be able to provide the necessary services. Under the HIPAA privacy rule, can you actually engage in telemedicine? For example, could you use email or maybe Google or FaceTime or other things like that to communicate with the patient? Well, probably under the privacy rule, yeah, you can do it under the privacy rule so long as you put in place reasonable safeguards. What are reasonable safeguards? Well, who knows? It's kind of whatever the OCR says they are after the fact, but things like making sure you're not doing anything stupid with the information, making sure you've got the right address, that type of stuff. The privacy rule does not prohibit the use of unencrypted email or presumably other telemedicine methods for transferring information. But that's the privacy rule. You still got to comply with the security rule. Remember, the security rule is more specific than the privacy rule. Under the security rule, you must implement specified physical, technical, and administrative safeguards for electronic protected health information, including these. Under the transmission security standards, you've got to implement technical security measures to guard against unauthorized access to information that's being transmitted over an electronic communications network. That's a required standard. In addition, there's two addressable standards. Under the integrity control standards, you've got to implement security measures to ensure that electronically transmitted information is not properly modified. And encryption. That means that that's an addressable standard. You've got to implement a mechanism to encrypt EPHI information whenever deemed appropriate. What's the net result of this? Does the security rule allow you to send electronic protected health information in an email or over the internet? The general rule is, well, it depends. You've got to comply with the security rule. The normal rule under the security rule is you've got to protect that information during the transmission. That means the addressable standard is encryption. The default standard is encryption. That means you have to encrypt that data during transmission or otherwise make sure that it's safe. Now, encryption's an addressable standard. That means if you're not going to encrypt it, you've got to come up with other standards and document other standards that are reasonable under the circumstances and that provide the same level of security. There's an FAQ on the OCR's website that specifically says that, hey, the security rule does not expressly prohibit the use of email for sending EPHI. That would presumably apply to other types of data transmission services. But you still got to comply with the security rule, including encryption, unless you can satisfy the standards for coming up with an alternative that gives you the same security protections. Now, there's an exception to that. Under the Omnibus Rule, the question was, well, wait a minute, does the Omnibus Rule prohibit us from communicating with our patients via email over an open network? The general rule is, hey, open network, that's not secure. So under the security rule, the general rule is you cannot communicate with your patients via email. But wait a minute. We also know under the privacy rule, patients have a right to receive communications by alternative means or alternative locations. That means that if the patient wants to or agrees to accept communications via email, text, or other means over an unsecure network, you can do that, so long as, under the Omnibus Rule commentary, you notified the individual in advance, and the individual basically, that you notified them that there are some security risks in doing that, but the individual indicates that, yeah, that's fine, I want to go ahead and do it anyway, then you can go ahead and communicate with them even though the network is not secure. What does that mean for telemedicine providers? That means if you are using an insecure open network to communicate with your patients, presumably the FaceTime or some other process like that, it's an insecure network, a not secure network. In that situation, you can probably do that so long as you notify the patient in advance and the patient agrees to that. Presumably, you would want to document that somewhere. That applies to communications with patients. Does it apply to communications with other providers? No.
The Omnibus Rule exception does not necessarily extend to other providers. You could have it extend there, but you would have to notify the patient and presumably get the patient's consent on that. That normally doesn't happen in your communications with other providers. So the general rule is in your communications with other providers via telemedicine, you need to make sure that you've structured that and you are using secure networks in order to communicate with them. In the materials that I've given you that article I drafted dealing with HIPAA and unsecure networks, emails, text. That gives you more guidance concerning those principles. But what about business associates? Remember, under HIPAA, if you are using a third party to provide certain services on your behalf that involve the creation, retention, maintenance, or transmission of protected health information, you've got to have a written business associate with that other entity. If you are a telemedicine provider and you are using some third party to help you in that process, you're probably going to need to have a business associate agreement with that other entity. That would include if you're using another entity to store protected health information or to transmit the information, and if transmission, if the transmitting entity is going to have routine access to that information, you're going to need a business associate agreement with them. On the other hand, if it's a transmission entity and they are merely a conduit, they don't routinely access the information, you do not need to have a business associate agreement with them, but it might be a good idea to have a confidentiality agreement with them. That applies to business associates. Now, you don't need to have a business associate agreement with other treatment providers who are participating in the telemedicine. For example, if you are a telemedicine provider, you don't have to have a business associate agreement with the hospital or vice versa. Business associates or healthcare providers, while providing treatment, are not business associates of each other. You got to be concerned about some additional regulations, including the FDA. The FDA regulates medical devices, which may include certain types of telemedicine equipment. In 2013, the FDA issued guidance on mobile medical apps. There's periodic updates that have been issued. You just want to make sure that you're checking with all of that stuff. All right, in the final 4 minutes, let's talk briefly about reimbursement, because you guys all want to get reimbursed for services. Traditionally, telemedicine really wasn't subject to reimbursement. It was hard to get reimbursed for that. That is changing. Reimbursement for telemedicine is expanding, but it's expanding slowly. In fiscal year 2015, CMS did expand the services for which it would pay for or reimburse for telemedicine services. There were about five additional codes that were added to it, but there's still a lot of limits that apply. In addition, this past year, CMS did confirm that ACOs can provide telehealth services. They can use telehealth as a method to reduce costs and participate in the Medicare Shared Savings Program. That's good. But CMS has been moving slowly on a broad application of or broad reimbursement for telehealth services. There is speculation that one of the reasons that they move so slowly is, hey, if we make these telehealth services more available, then people are going to get more services, and that's going to be an additional drain on healthcare services, and we don't necessarily want to go there because we're already overdrawn on our Medicare bank account. Other people argue, well, the telehealth services, they're less expensive and they actually end up saving money. You know, who knows how that shakes out. The bottom line, though, is CMS is moving slowly on providing reimbursement for telehealth services. Medicaid programs generally provide some coverage, but it really depends on this particular state, so you need to be aware of what your state does and doesn't cover. Well, what about private payers? Well, private payers are normally, it's a matter of contract, with this exception. Now, in 27 different states around the nation, 27 states have implemented or promulgated statutes that basically require managed care contracts, insurers to pay for telehealth services the same way that they would pay for in-person services. You'd have to look at your particular state to see whether or not you have those parity laws. Here in Idaho, we don't have those parity laws. In some other states around in the West, in the Intermountain West, there are. But you need to just double check that. Even if the states don't require these private payers to pay for telehealth services, a lot of payers are moving towards paying for those services because they see it as a way to actually reduce costs. By providing those services through telehealth, they can forego more additional procedures and the like. When it comes to Medicare and Medicaid, in the interest of time, the bottom line is, yes, for Part A, you've got to satisfy the conditions of payment. For Part B, CMS will pay for telehealth services, but there's a lot of strings that are attached. It's got to involve an interactive audio and video telecommunication, permitting real-time communication between the practitioner, the distant site, and the beneficiary at the originating site. It, at least currently, cannot be asynchronous or store and forward technology. The patient has to be present and participating in the telehealth. The originating site has to, it only applies to certain types of entities, and those entities have to be located in essentially a rural area, either in a rural HPSA or a non-metropolitan statistical area county. There was a lot of pushback this past year. A lot of people wanted the CMS to expand that to allow for telehealth services outside these rural areas, but so far CMS has not made that change yet. The originating site has to be a certain type of facility. The distant site practitioner has to be licensed under the state law to provide the telemedicine services at the originating site, and it only covers certain types of practitioners to provide those telemedicine services. The covered services include, there's a long list in the materials that I provided to you. I gave you the most recent MedLearn on this issue. As I mentioned, this past fiscal year, they added 5 new categories where CMS will pay for those telehealth services, but you still got to satisfy those other requirements about the originating site, the distant practitioner, and the like. When it comes to reimbursement, usually you can get a facility fee for the originating site. It began as relatively modest, and it's increased slightly over time. The payment can be made to the physician at the distant site, but you've got to use an appropriate modifier. There's limited reimbursement and less strings attached with that. All right. That is it. I've got 101. Just in closing, additional resources. The Federation of State Medical Boards has provided a lot of information dealing with telemedicine and the applicable licensure rules. I would encourage you, if you've got those questions, to use that or look at that information. I provided a couple of those state surveys to you. Great information is also contained on the Center for Telehealth and eHealth, or the CTEL website. And the American Telemedicine Association also has a bunch of resources. It's probably the most active organization out there focusing on telemedicine issues. As far as resources we have additional resources on telemedicine issues as well as a bunch of other issues. This concludes this webinar. Our past webinars, if you're interested in any of our past webinars, they're available at our website. We've got some future webinars coming up. Looks like I'm on deck for EMTALA in August. In September, we'll be talking about credentialing, corrective action, and data bank reporting. In October, we'll talk about interpreters and translators. And in November, just in time for the holidays, we'll talk about gifts to or from patients and referral sources. If you would like to receive updates concerning these webinars or other email alerts, feel free. You can contact me and we'll get you added to the list. There's no charge for that. And that is it for today. If you have any questions, again, feel free to shoot those to me either by email and use that chat function, and I will contact you offline. We always appreciate your participation in this. If you have any suggestions or comments for future programs, let us know, and I hope you all have a great summer.